Well, if there's ongoing litigation, presumably it's not in the bankruptcy court. If it is, then the judge can certainly consider what's going on there. But ultimately, lawsuits tend to be about money. And whenever anybody says, no, it's the principle of the thing, the principle is money. I think that my cynicism may be showing. I apologize. I should cover it up. In any event, if there is litigation pending, let's say, and while I am here in California in the California Superior Court, it means that each side thinks that it has at least a colorable argument and maybe even a winning hand. When the smoke all clears on that lawsuit, then the parties can determine whether each party can determine whether or not to appeal. So there are two possibilities here. Well, I suppose there are more, but these are the salient ones. Either the debtor wins or the other side wins. Let's say the debtor is suing this other party to get money. If the debtor wins, the debtor gets that money that can be used to fund the plan, and that could make the plan feasible when otherwise it might not have been feasible. Or let's say the other party is suing the debtor and wins. Well, now that creates a claim, or now it's a liquidated claim, and now you have a sum certain, and that sum certain may be too much for the debtor to be able to take care of in the Chapter 11 plan. Another problem with feasibility. So what can happen is the judge may stay the proceedings pending the resolution of the state court action. That's probably not going to happen, although it can, for the obvious reason that state court proceedings can take a very long time. And depending on how far along that state court action was when the debtor filed the Chapter 11, you could end up with years later. So there could be perhaps provisions in the plan to hybridize, to deal with the taking care of whatever the results are in that state court action. Maybe if the creditor is suing the debtor and wins, there could be a statement saying that this debt not being part of the plan could be determined to be non-dischargeable. Of course, there are questions of due process that get folded into that question. So the problem here in answering this question is there's an entire continuum between a fresh lawsuit and one that is near to resolution. And where along that continuum the lawsuit is will play a big role in how the judge wants to treat it. If it looks like it's going to be resolved pretty quickly, the judge may just temporarily stay the proceedings pending the resolution of that. If it looks like it's going to be a long time, well, then the parties are going to have to brief that and explain to the judge why the Chapter 11 case should proceed apace anyway. It's not a very satisfying answer to your question, and the reason it isn't is because there are too many moving parts to really do much more than give general principles.